Ready? Start. Sri Rajiv Lochan Shukla, learned counsel for the appellant, while advancing his submissions, has urged the prosecution begin with the story of suicide by disclosing this basic requirement in the FIR itself, where PW1, the informant, did not raise any suspicion of murder and rather indicated the case to be an abatement of suicide. He therefore submitted that the later development of the case into an offence of international murder for the sake of and demand of dowry was a clear transformation in the basic case of the prosecution by two of the witnesses, PW1 and PW2, who proceeded to depose before the court for the first time about the allegation of dowry, for which neither the appellant nor other co-accused were found guilty. The trial court, according to Sri Shukla, has rightly found that there was no evidence to conclude that there was any demand of dowry or otherwise was the motive for the alleged incident. Even if it is homicide, in the absence of motive or direct evidence, the question of inferring murder having been committed by the appellant does not arise, and therefore the conclusion drawn by the trial court can be said to be based on surmises and conjectures and not on any evidence existing on record. Sri Shukla then urged that even the case of abatement of suicide was not established in as much as the statement of PW1 and PW2 are brother and father of the deceased are in conflict in themselves and against each other as well. Sri Shukla submits that the statement of these witnesses read as a whole fails to establish the case of harassment for dowry, the statement or torture by the husband for not performing the duties of a housewife, in as much as if the prosecution has failed to adduce any evidence relating to suicide or its abatement by the appellant, then even otherwise there is no scope for any inference about the case of the appellant having abated the same. It is further argued that the charge framed in the alternative under section 302 IPC was added with section 34 IPC, and if the trial court has acquitted the other three co-accused and has not found a joint liability on the strength of section 34 IPC, then acquittal of the other three co-accused should be read in favor of the appellant to the extent that the appellant could not have been convicted without there being any specific or independent charge simpliciter under section 302 IPC. He therefore submitted that evidence which has come forth clearly indicates that an incorrect charge having been framed and no offence having been established on the basis of evidence adduced, it was neither a case of abatement of suicide or of murder. In addition to the said submissions, he contended that the other circumstances should also be taken into account, namely that the state did not file any appeal against the acquittal of the three co-accused. There is no recovery of any instrument or weapon at the pointing out of the appellant, which according to him is a necessary ingredient in order to prove a case of murder, and further that there are no independent witnesses in spite of the fact that an incident is a broad daylight incident. He elaborated his submissions by contending that the issue relating to section 106 of Evidence Act as discussed by the trial court does not take into account the fact that the incident has taken place in a cattle shed beyond the residential premises of the appellant, and therefore there is no reason to presume that the premises where the incident has taken place was in the exclusive occupation of the appellant. He contends that all such infirmities in the case of the prosecution, and the circumstances aforesaid nowhere by any stretch of imagination lead to the inference that the appellant may have been involved in the murder of his wife, much less there being a probability of the same. Over.